Hello everyone, my name is Elif İplikçioğlu. I'm the brand ambassador of Turesta Real Estate. Today I will answer your questions on what to do and not to do when buying a real estate in Turkey. Question 1. What are the considerations while buying real estate in Turkey? Buying and selling real estate in Turkey is increasing day by day in the face of today's economic needs, attracting a great deal of attention from foreign nationals as well as Turkish citizens. Although the part after the payment seems like a simple buying and selling procedure, in fact, real estate buying and selling requires serious research and following fundamental steps. Considering the fact that thousands of lawsuits are filed in Turkish courts every year regarding the ownership of immovables, the importance of the issue is better understood. Whether for investment purposes or residence purposes, there are essential elements to be considered in real estate buying and selling in order to avoid problems between the parties. In our explanations, the factors that should be considered for a problem-free real estate purchase are mentioned. Question 2. What is an examination of land registry? Due to the fact that the title deed record of the purchased real estate is not examined before the purchase, many conflicts are encountered. Land registry records must be examined before purchasing real estate so that the buyer does not experience any loss of rights and does not encounter any unexpected situation in the post-sale process. Question 3. How does the process flow? The principles of trust in land registry and publicity are essential in the Turkish legal system. All real estate transactions are carried out at the land registry office, where the real estate is located, and the current status of the real estate is stated in the land registry records. In accordance with the principle of publicity, regarding the title deed records, the title deed registration can be examined and investigated by any interested party. Therefore, before the real estate purchase, examining the title deed records of the relevant real estate is an important factor in the healthy completion of the purchase and sale transaction. Question 4. What should be considered in land registry records? The real owner must be learned. It should be investigated whether the person making the sale is the owner of the real estate in question, and if he's performing the sale by proxy, and whether he has the necessary power of attorney. Try to buy from a local citizen. As we have mentioned before, since the law is based on the principles of trusted land registry and publicity, it is easy to understand who the real owner of the real estate is from the land registry records. Not knowing who the real owner of the real estate is, subject to sale, is not protected by the legal order. The purchase of real estate from a person who does not appear as the owner of the title deed is considered an invalid sale before the law, even if the buyer has good intentions. For this reason, those who want to buy real estate should first examine the title deed record of the relevant real estate, and it should be investigated whether the seller is the owner in the title deed or whether there's a duty authorized to whom the sales authority is given by the owner. Question 5. What other factors should be considered? It should be learned whether there are limitations such as mortgages, liens, precautionary measures that may prevent the sale, affect the value of the immovable, or require the responsibility of the buyer in the registration of the immovable. Although there are limitations on a real estate, such as mortgages, foreclosures, and measures, it does not prevent the sale. This situation should be investigated from the title deed before the sale. Because in case of sale, the real estate will be transferred to the buyer with the said limitation, so the buyer must know and accept this. Otherwise, it will be possible for the buyer to experience irreparable damages in the future. In other words, before the sale, the buyer must know the limitations on the real estate, whether there's a mortgage, lien, or precaution on the real estate, and must accept the situation with its consequences. Question 6. What is a review of municipal records? Municipal records of the real estate to be purchased should also be examined. Because the recent fate of the immovable to be purchased, its zoning status, whether it has a building occupancy permit, whether it has a property tax debt or not, can only be learned in a healthy way by examining the municipal archive file of the relevant immovable. These issues can play an important role in the buyer's decision to purchase the real estate, and knowing these issues by the buyer will prevent an unexpected situation in the future. Question 7. Why is it important for the real estate to be examined by municipal records? As a result of the examination of the municipality records and inquiries from the relevant units of the municipality, the fair value of the immovable can be learned in a realistic way. Knowing the fair value of the real estate correctly has a great effect on the purchase and sale transaction to be made in the title deed. The purchase and sale price to be declared to the Land Registry Directorate must be reported in accordance with this current value, since the purchase and sale price to be notified to the title deed cannot be lower than the current price. Question 8. What are the steps of signing the real estate sales contract? Real estate sales contract is a mutually executed contract in which the seller undertakes to give the immovable in return for the agreed price, and the buyer undertakes to purchase and pay the price of this immovable, and which covers the promises and commitment statements of the parties before the land registry officer. Persons who want to buy real estate must base the sales process on a legal document by signing a written contract in order not to lose their rights in the future. However, the fact that the real estate sales contract is in writing does not make the contract valid by itself. In order for the real estate sales contract to be valid, the contract must be signed in the presence of a notary public and announced on the title deed. The legislator stipulated that the real estate sales contract should be prepared in the presence of a notary public and announced on the title deed as a condition of validity. In this case, real estate sales contracts that are not made in the presence of a notary public will be invalid. And now I will give you tips about the procedures for the purchase of real estate in Turkey. Buying a property in Turkey is not at all difficult. This procedure is as simple as possible, fast, and at the same time reliable. The stages of the procedure for a standard real estate transaction are as follows. First of all, you should choose the property that suits your budget or the property that you want. Your sales contract must be signed by the parties or their authorized representatives. It contains information about the participants in the transaction, the property, the terms and conditions of payment for those transactions, the obligations of the parties. To sign the contract, the buyer is only required to provide a passport or power of attorney to the buyer's representative. The contract must be prepared in 2 copies and in several languages. It can be in Turkish, or if the recipient has another language of his country, it must be prepared in that language. The individual taxpayer number must be obtained. In order to pay for the utilities in the future, you will need a bank account in Turkey. You can pay for real estate in Turkey in any currency. This should be indicated in the contract, and the payment schedule is also indicated in the contract. When submitting the deed, the property must be fully paid for. The issuance of the title deed takes place in the cadastral office in the presence of a state translator. After receipt of the title deed, the buyer pays the rate, which is 4% of the cadastral and determined value of the property declared in the title deed once for the purchase of real estate. As a rule, the time for obtaining a title deed is up to 2 to 3 days from the moment the seller submits an application to the cadastral office. The final stage of the process is the registration of a subscriber's bill for electricity and water. Power of attorney is optional. If necessary and if desired, you can register your realtor or representative. The process of issuing a power of attorney takes place at the state notary in the presence of a notarized state translator. The power of attorney authorizes to obtain a subscription to electricity, water, and property insurance, as well as the necessary procedures for completing the purchase of real estate. All you need to do is to inform the Turesta authorities about the property you're looking for and the region you prefer. We will guide you with a portfolio of properties selected according to your requirements. Turesta will be at your service at all times. Thank you.